If it was to be granted, guess what? That is grounds for dismissal of all the charges. Because if the prosecution is responsible for misconduct that results in a mistrial, you're done.
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you with my pearl-handled pistol cufflinks so graciously gifted to me by our content genius, Michael Rivers, who is right behind the camera as we speak, who is responsible for all the words that come out of my mouth. I just work here, man. The lawyers for YW Melly have asked for a mistrial and made a motion saying the prosecutor created misconduct when they did certain things during the trial and the cross-examination, or when they called Miss Holmes, the girlfriend's mom, as a witness. And remember, we're going to go through a little bit of her testimony and then we'll watch what the defense motion is, and we'll kind of analyze this and see what does it all mean. But before we get to that, God, I tell you, my grandparents, you guys know all about my grandparents, right? They have created this web OnlyFans business in my basement, and they won't leave the basement, and they're making oodles of money with their foot pics. It's just unbelievable, and they've created just so much trouble for me. I got to get them out of there. So, and I can't leave the house, so I use eSign.com to get a lawyer to sign an agreement so they can get them out of there with a restraining order. But, you know, eSign.com is a great way to remotely do business, and I use it all the time in my practice. You download the app, you get 3 free signatures a month, and you can remotely do business. You can use a power of attorney, you can do it for a restraining order, you can do it for a retainer agreement, or buy-sell agreement, or a business agreement. It's a great way to just keep the commerce flowing. I hope your grandparents, you know, my grandparents have just absolutely nasty, ugly toenails. You know, the disease kink fetish is just absolutely running rampant, and I don't know what his deal is whether it's MRSA or whatever, but his black and yellow toenails are just so disgusting, but they're making oodles of money, and I really got to get him out of there. So eSign.com is an effective way to get your grandparents out of your basement. eSign.com. If it's not eSign, no one signs. So let's get into this. We reacted a little bit to this testimony, but I kind of want to review it again, and review it in the way of through the defense lens and their motion. Okay, so let's just watch her, because there's some implications here that in insinuations that the prosecutor made that are the basis for the defense motion for a mistrial, and I'll tell you about what that means when we get into it.
Why you came down?
I told you why I came down.
Okay, why is that?
Objection. Asked and answered.
Sustained.
Okay. Ms. Holmes, have you ever let me rephrase.
So now the prosecutor's, she's like 2 minutes into this, and she's rattled to shit. She doesn't know where to go with this hostile witness. She knows what she wants to get in, but the witness is not helping her whatsoever. And there's an implication that she was paid off by the defense. And I don't think there's any evidence that that's true.
Did your daughter ever threaten to cooperate with law enforcement?
Objection.
Did your daughter ever threaten to cooperate with law enforcement? Now, that's clearly hearsay. And there's no exception to that.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come sidewalk? I want you to question, please.
Ms. Holmes, did you ever make any statements about what happened on October 26th of 2018?
Objection. Asked and answered.
I don't know what statement you're talking about. Rephrase your question to specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidewalk, please.
So
So she's really trying to get in any statements that she may have made about what happened inside the courtroom. First of all, she wasn't there. So anything she saw, or not saw, but anything she heard about, the answer to that question requires a hearsay response. I heard this from so-and-so. And if it isn't from Melly saying I did that, then you can't get it in.
Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17, I had been present.
No. Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on
Because it's hearsay, and you can't get that in through this witness.
when you came down to Fort Lauderdale.
All that shuffling of papers is so distracting. All this, airtime, dead air, is shows that she's not prepared.
Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Calls for a conclusion on part of this witness.
Based on your daughter's demeanor,
She was
how was she
Objection.
acting?
Sustained.
See, the prosecution's not getting anywhere with this witness, and how she doesn't know that she's going into this objection buzzsaw, which is really what it is. She needs to just get the witness off and just go on with the rest of her case. But she's running dangerously afoul of the court's prior ruling. Now, keep in mind, they're going to be asking for a mistrial later, and this is why.
When you arrived in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection.
What's
Asked
the
and
objection?
answered.
Overruled.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
All that was completely ineffective.
I have one question.
Yes, sir.
You came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Good question. I love a good, when to not ask a question, when to stop asking questions, that is just as powerful as asking the right question, knowing when to quit.
Anything else to this witness?
Yes, Your Honor. Ms. Holmes?
Yes.
You said you feel threatened by
Of
me.
course.
Okay.
Why the hell is she even going there? This is called balls. That answer to that question affected her ego, and now she's going to allow her to explain. You don't do that.
You failed to appear for numerous court appearances.
No, I never served me. Lied.
Okay.
You lied to the court.
And with regard
You lied to the court. See, she shouldn't be doing this. This is just
to, did you work in Redding, California?
Yes, I did.
Okay.
Immaterial.
Overruled.
And so that was a location you were at?
That's why I was a travel nurse at. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next week, and I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of.
See, what is she getting at? You don't ask questions unless it benefits you, And so this little soliloquy between the two of them is just not benefiting the prosecution. In fact, it's explaining the hostility of this witness, and I don't think it's coming out favorable for the prosecution.
2019.
You never served me. I know you served me to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
anything about the courthouse.
Excuse me, come sidebar, please.
You even went so far as to hire an attorney
Yes,
to
I
try
did.
not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal.
Apparently, what she's talking about is that because the state has asked her to appear, and if you remember, I did a video a while back because they were trying to find them, both the daughter and the mother in this case, and they were having trouble because they weren't showing up for, they supposedly subpoenaed them, didn't show up for subpoenas, so they wind up putting an ankle monitor on her, and she said so they can keep track of where she is, and because she's a material witness in a homicide, double homicide, and so she's like, the state has ruined my life. I mean, she's not the criminal here, and I think her testimony is so off a little bit, just very, very not central to the issue. And think about how that would feel. You didn't commit any crime. You're not really part of this case. I mean, you are part of this case, but you're just a witness. And the state's really coming down on you hard because, they want you as a witness. And so, but that's the only way they can secure her testimony. Because, here's the thing. When you don't show up for a subpoena, they can arrest you. And so, short of them keeping her in jail, that's the least restrictive alternative. In other words, giving her a ankle monitor. But it's still very intrusive for the government to do that to a witness.
When you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, sir. So my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued,
Yes.
you're aware that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go over.
All these questions come after him just saying who intimidated you. And look what she's doing. She's intimidating, or trying to intimidate her.
Thank you for the Fourth District Court of Appeals.
He had to hire an attorney because he tried to get him this far.
And
She said he hadn't hired an attorney because you're trying to get him disbarred.
no, that's a false statement.
Objection.
Excuse me. Counsel, you're not testifying, all
I
right?
agree.
So she's asking questions and doesn't like the answers. Is cross-examination 101. And now, so her making that's a false statement. You can't just say shit like that.
Excuse me, you asked a question, all right? That's it, you asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney,
Yes.
Objection asked and answered fucking 8 times.
and you then tried to get any sort of court order requiring you to be here in court thrown out.
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid.
You never served me a subpoena that was you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court.
Objection.
All this after that one question that the defense asked. Who intimidated you? The state. And now you learn that she's wearing a fucking ankle monitor. You know that they're chasing her down with subpoenas, and and they are intimidating. I mean, she just proved the point.
That's an answer.
Sustained. Excuse me, sustained.
And so, with regards to your feeling threatened on that, have I ever any sort of physical violence against you?
No.
Okay. Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time.
And
Asking that.
You're intimidating me right now. I mean, she's proving her point.
And in terms of your participation in this case,
Yes.
you understand that you were served a subpoena to appear here today.
You served a subpoena after you arrested me.
And
You served
you
a
have-
subpoena at the jail when I
and
was
you have-
around.
All this shit should not even come in. You arrested me. You put an ankle monitor on me. If that's not intimidation, I don't know what intimidation is. By that one question that the defense asked, do you feel intimidated and who intimidated you? You got all this shit out that you got arrested, you put an ankle monitor on me, you're making sure that I show up to court, you subpoenaed me, but you didn't subpoena me, I didn't see it, I had to hire my own lawyer. Doesn't that sound like the government just coming down on you? So, if anything, she seems sympathetic now. It wasn't in this clip, but we're gonna watch the motion for a mistrial. So the judge has not ruled yet on the motion for mistrial. We're just gonna watch the defense's argument because they are saying that she violated Rule 8035, which is, the recorded recollection exception to the hearsay rule. And they went over and over and over and over again. And we saw how adverse that this Miss Holmes was to the state. So let's just watch the motion for a mistrial. And if it's granted, which it's not going to be, but if it was to be granted, guess what? That is grounds for dismissal of all the charges. Because if the prosecution is responsible for misconduct that results in a mistrial, you're done.
Sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, it advanced a ruse pretext that they were seeking to do so under 8035.
So, essentially what he's saying is that they didn't have the girlfriend. I don't think they have the girlfriend as a witness. I'm not sure about that, but that's kind of what it seems like. So they're trying to use the mom because now they have her under lock and key, right? And they're trying to use the mom to get in evidence that wouldn't otherwise be admissible. And they are trying to pull wool over the court's eyes. And basically, they were able to shut him down. Now, here's the thing. The mistrials only, what's the remedy for prosecution misconduct? Well, you can do one of two things, one of many things, but you can exclude evidence. You can have an instruction to the jury to disregard what the state was doing. But if it's so bad that you can't unring the bell, as it were, then it is grounds for a mistrial.
It turns out that 8035, given the witness's testimony, could not be employed. And
what are you saying? Let me grab my rule book here. So what are we talking about here? We're talking about rules of evidence, and it's 8035. Anything in the 800s usually deals with statements of witnesses, and so these are 803 is all the exceptions to the hearsay rule. Hearsay generally is inadmissible unless it falls into one of these exceptions. Hearsay is a statement other than the declarant offered in court to prove the matter asserted. So it's somebody else, not the person that we're dealing with, right? And so a memorandum or record concerning a matter about which a witness once had knowledge but now has insufficient recollection to testify and accurately shown to have been made or adopted by the witness when the matter was fresh in the witness's memory, and to reflect the knowledge. In other words, so there's these text messages by Melly and by her daughter, and it's just inappropriate to have that come in through this witness. So let's continue to watch the defense's motion.
the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done.
So, and here's why that's important. If the court's already admonished the state to not do something, and then they do something anyway, and they're trying to, get in the back door, for lack of a better word, that is prosecutorial misconduct. That's serious. And if it can't be cured with an instruction, can we unring that bell?
and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise.
Well, how could it be a fucking surprise if you got to put an ankle monitor on the person that you need as a witness? I mean, if you had to arrest her and put an ankle monitor on her, don't you think she's going to be fucking hostile?
That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do.
So the statements of lawyers are not evidence. Okay? So when she made the statement, well, that's a false statement, you can't, the lawyer can't testify. You can't testify in your own trial. You just can't do it. And so even if she doesn't get this stuff in, she's trying to taint the jury and give the implication of what's contained in those documents just by inference.
The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it,
I think one of the implications there that he's talking about is that the defense paid the witness off.
after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the...
Now here's the thing. Is this judge going to toss out a double homicide because of this? I highly doubt it, but he will have to instruct the jury very sternly if he doesn't throw it out.
Admissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't...
There's always one more thing. Lawyers like to hear themselves talk. And I've always found the more I talk, the less effective my argument becomes. I like to get in there, get out of there.
Motion for Mr. Addison?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, it's second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness.
That is serious. I mean, for her to go down that road without solid proof of it is really damning. And how, like I said, how do you unring that bell? How do you get them to unhear what the jury that is, to unhear what they just heard?
And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it. It's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes had been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh.
But it's hard not to just get up and because the tensions are high. Tensions are really high in that courtroom. It's a little bit gets lost because we're not participating. But when you're in that, I guarantee the prosecutor and the defense team in this instance fucking hate each other.
Have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the implication, or not implication, the accusation.
And here's the thing: does she really need to go there? It's a circumstantial case, right? So they don't have a smoking gun, for lack of a better. Well, they don't have a gun, period. But they don't have anybody saying that Melly did this, or do they? Bortland's the only one that can do that, right?
Made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it on based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question.
And if you stray outside of those strict conditions, it's prosecutorial misconduct.
Because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their...
Look at the look on his fucking lawyer's face, the white dude there. He looks just like he's going to pounce. He's just going to fucking pounce on her in a second.
Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law.
When you have an order from the court and you violate it, you have to be sanctioned. And what is the sanction? That's really kind of probably the only issue here. And the judge could say, well, you know what, I do agree with the defense that the prosecutor went outside the bounds of my order, so I'm going to instruct the jury. I'm not going to issue a mistrial, but I am going to instruct the jury to completely disregard any of the remarks surrounding that issue. That's probably what's going to happen.
By coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced.
And really, that's the long and short of it. If they're irreparably prejudiced, so that they can't be fair and the bell can't be unrung. And here's the thing: when somebody gets an instruction, do they really listen to those instructions? Sometimes they do. Sometimes, the research on it is that the instructions aren't that effective. So this has been our reaction to the defense seeking a mistrial based upon the cross-examination, or basically the adverse examination by the state of their witness that's not really cooperative. And, he asked one question and asked her, who intimidated you? And he said that she did, the state did. And, by what? By getting her arrested, by putting an ankle monitor on, by ruining her life, as she said. And she didn't even have to ask another question. But she went down this road, and she absolutely proved the point of the defense. So we'll see tomorrow. I bet there will be a ruling tomorrow morning about whether or not the defense motion for a mistrial is granted. If it is, it's prosecutorial misconduct. The case gets dismissed. I don't think the judge is going to have that much desire to just chuck a double murder case based upon that violation of the rules of evidence. But we'll see. If the court grants a mistrial, the case is over, and they can't retry him. If the court doesn't grant a mistrial, there'll probably be some kind of an instruction, I would bet, and then the state will pick up where it left off. Now, remember, there's an issue about whether Bortland's going to testify, and Michael doesn't really want me to go into this, but I'm going to go into it anyway. My prediction is he testifies. It's too valuable. It's too eyewitness to not have him testify. I've always thought all along he's going to testify. And, and I made some comments about his statements earlier on, that his own interview doesn't come in. But the reason his own interview came in without him testifying is because it wasn't offered for its truth, because it wasn't true. The things that he's saying weren't true. And if it's not offered for its truth, then it's what? Not hearsay. Because hearsay is a statement other than the declarant offered for the truth of the matter asserted. Well, if it's not true, then it's not hearsay. What's going to happen here is they're going to get to a point in the trial, and Bortland is going to testify. That is my prediction. How do they not have him testify? And I think he's cut a deal. And that's just my guess. And I could be wrong. And if I am, we'll analyze that too. But my guess is that he is going to have to testify, and he's going to testify. Because this is a circumstantial case until you talk about Bortland. Bortland was there. He saw everything. He drove the guys to the hospital. And he made up the story that it was a drive-by, which isn't true. So we'll see it when it happens. We'll see tomorrow morning and see what happens with the mistrial motion. And we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, so proudly presenting this episode to you with our content genius, Michael Rivers. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away.
23-hour lockdown, please, is that my God.